Hello friends, welcome to EduSathi, your partner in education. In this video, we will be continuing from the law of contract which we left in the previous video. It's in continuation with the previous video of legal reasoning 5. So let's continue. We had left the previous video on the concept of ingredients of a contract. That is, to a contract to be a legally valid contract, there must be these 5 essentials or ingredients, that is lawful object, competency of parties, lawful consideration, free consent, and not expressly void. That is, these 5 ingredients must be present to form a legally valid contract. So we will start discussing these by one. First is lawful consideration. What is a consideration? A promise for a promise or something in return of something. So this amounts to a consideration. Example, A sells to B 500 bags of grain for rupees 1 lakh. So rupees 1 lakh and 5 bags are consideration for respective parties. For A, 500 bags are consideration. For B, rupees 1 lakh is a consideration. So in return of 500 bags, you give 1 lakh rupees. So it means something in return. Essentials. Consideration should be legal. It should be something which is legal in the eyes of law. Consideration should have some real values in the eye of law. For example, A asks B to give him rupees 50, and in return B would pray to God that A gets beautiful wife or son or a good job, etc., something of that sort. So it would not amount to a consideration. Praying to God is not something which has real values in the eye of law. So it is not a valid contract since there is no valid consideration involved. Adequacy of the consideration is immaterial. The question here is that whether the consideration is adequate or not, it's not upon the court to look into. The consideration could be anything which has value in the eye of law, and it does not amount if it does not matter if it's adequate or not. Let's take an example. A offers to B a plot of a land worth rupees 50 lakh for a consideration of 65 lakh. A reasonable man would say that 65 lakh is unreasonable and inadequate for the plot of rupees 50 lakh, but in the eyes of law it's a valid contract because it would not matter whether the consideration is adequate or not, so it's a valid contract. Similarly, if he offers same plot of 50 lakh for 50 lakh or even for 10 lakh or even for 5 rupees, it would not affect the validity of the contract. So for the consideration to be valid, it has to be a legal and something which has real values in the eyes of law, and adequacy of the consideration would not matter at all. It's immaterial. Next thing is unilateral promise or promissory estoppel. This is an exception to the general rule of consideration. When one person does something or acts at the instance of another, then it becomes a valid consideration. By your saying something, other person has acted upon your words, so it would amount to a valid consideration. It would result into a valid contract, and it is known as promissory estoppel or unilateral promise. Example, A and B were watching a movie in A's house. A asked B to get a pizza and that he would pay B for pizza when he gets it. So B accordingly goes and gets the pizza. So B has acted upon the words of A. Later, A refuses to pay. Yes, this is a valid consideration and it's a valid contract. B can actually force A under the eyes of law for making the payment of the pizza because he has acted upon the words of A where he said go and get pizza and he would pay for it. Okay, so it's a promissory estoppel. Example, A wanted to get the community hall repaired. He approached B in order to arrange funds. B promised that he would contribute rupees 50,000 to the project. A got the hall repaired. When he asked B to give him the promised rupees 50,000, B refused, saying that there was no consideration. So it's a valid contract, and B can force A can force B to pay him rupees 50,000, because the rule of promissory estoppel applies, because A had acted upon the words of or promise of the person who agreed to pay rupees 50,000. So it's a valid consideration and a valid contract there too. Next concept is consent. We had discussed the concept of consensus ad idem, that is meeting of the minds. Meeting of minds. It means both the parties agree upon the same thing and in same sense. We had discussed the example of the car where both the parties were thinking about buying or selling different cars. So in that case there was no meeting of the minds, because I was thinking that I'm selling you my Centro car for rupees 1 lakh and you were thinking that you are buying my Honda City for 1 lakh. So there was no meeting of the minds and consensus ad idem, so there was not a valid consent. For the contract, a contract can be bad for two reasons. One, there is no consent. Second, there is invalid or no free consent. In case of no consent, it could be due to a mistake, which is void-ab-initio. We discussed void means which is not right from the very beginning. Ab-initio or ab-initio means from the very beginning. So the contract would be a void agreement. It would not be a contract in case of mistakes. For example, we had discussed in the law of torts that mistake of law is not an excuse, right? So any contract based on the fact that we did not know that there is law which does not which says that gambling is not allowed. If we enter into an agreement on gambling and we take an excuse or say that there was a mistake, that we did not know that law does not allow gambling, so it's a void agreement, which is void from the very beginning on the basis of the mistake, and it's not a legally enforceable agreement, because there was it would be considered that there was no consent due to mistake. Invalid consent and no free consent can be taken by these ways. One is mistake, second is coercion, undue influence, misrepresentation, fraud. All these concepts would be discussed in further slides in detail. Here we can just say that mistake renders the contract to be void, that is not right from the very beginning, and it would not be valid in any case, even if the parties want it to be valid and legally enforceable, even though it would not be, even in that case it would not amount to be a valid contract. So the mistake renders the contract to be void from the very beginning. However, these cases where no free consent was given, the contract is voidable at the discretion of the parties, where either of the parties has a right to keep the contract valid and enforce it legally. So it's a discretion upon one of the parties concerned. So in these cases the contracts would be voidable contracts. It's a voidable, in the first case it's a void agreement, and in the second case it's a voidable contract which is voidable at the discretion of one of the parties concerned. Let's discuss the concepts under the no free consent. First is coercion. What is coercion? Coercion is committing or threatening to commit any act forbidden by Indian Penal Code. It's a law which provides for the provisions related to the crimes which are punishable under Indian Penal Code, or the unlawful use of threat or use of physical force. Any act or threat, any committing of act or threatening to commit act which is forbidden by IPC, or use of threat or use of physical force would amount to coercion. Unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, something other than physical force. This would also amount, these are the two types where coercion would result in. It's an unlawful detaining of a person or property, or threatening to detain such person or property which will harm or prejudice to the other person. This would also amount to coercion, with an intention of causing any person to enter into an agreement. These two acts are done with an intention of causing the person with whose property or person the such acts are done, and causing that person to enter into an agreement. So there is a force, these two types of force used to force the person. Coercion is a force to force the person to enter into an agreement and contract. So it's a voidable contract on the party of the person later on who was forced to enter into an agreement. It's a discretion of the person to whether that person wants to keep this contract valid and enforceable in the eyes of law, that this person can actually breach the contract on the grounds that he was coerced to enter into an agreement. So let's take some examples in what cases the coercion is resulting. Example 1. A threatens to commit suicide if B, his father, does not give him his property. Is this a coercion? There's a difference between coercion and love. If some person gives into a contract or agreement out of paternal or maternal love, that would not amount to a coercion. For example, you ask your father that I want this much money or this gift on my birthday, or I will not come home on the same day, or I'll do something which you will which you will regret later on. So if the father gives you that gift, that would not amount to coercion. It's out of love. In this case, the person threatens to commit suicide. It's a threat which is of an act which is forbidden by IPC to his father, so it would amount to coercion. He cannot force his father to deliver the property on the basis of the act which is forbidden by IPC. Example 2. A threatens B that he will shoot A's wife W if B does not sell off his flat worth rupees 1 crore to him for 70 lakhs. So let's apply this principle. It says threatening of committing an act which is forbidden by IPC. So murder is an act forbidden by IPC. So A has threatened B to enter into a contract that he will shoot his wife if he does not sell the flat worth rupees 1 crore for him to him for 70 lakhs. So if A enters into contract with B on the basis of this threat, then it would amount to coercion, and A and B later on can breach the contract on the ground, because it's voidable on his discretion, that he can breach this contract on the grounds that he was coerced to enter into this contract. Example 3. A took a loan from B and left title deed of his property as security. A repaid the loan. B asked A to sell off his house to him, otherwise he will not release the mortgage. So this is also a coercion, wherein he threats him that he will not release the mortgage or return the papers which he left the title deed with him as a security. So he will not give the paper back if he does not sell the house to him. So this also amounts to coercion. A can declare the contract void. It's on the discretion on A to keep the contract invalid and breach the contract on the grounds that he was coerced on these grounds to enter into a contract for selling his house. Another concept is undue influence. Undue influence is a contract. A contract is said to be induced by undue influence where the relations existing between the parties, it's an important part, that is, relations existing between the parties are such that one of the parties in a position to dominate the will of another and uses that position to obtain the unfair advantage over the other. Let's take the examples to understand the concept of undue influence. Example, B, a spiritual guru, convinces his disciple A that if A gifts all his property to B, upon death of A, he will go straight to the heaven. So here the concept says that there is a relationship existing between the parties. B is a spiritual guru and A is his disciple, and such that one of the parties is in a position to dominate the will of other. In this case, spiritual guru has the power and position to dominate the will of disciple A, and he uses that position. He has used this position by saying that he must give the property as a gift to B to obtain unfair advantage So B has obtained the unfair advantage of property of A by using the position of being spiritual guru over him. So it's a undue influence, and this contract is the contract resulting would be a voidable contract on the discretion of A. Another example, L, a lawyer, knows that his client C has committed murder for which B has successfully defended C. So in this case, the lawyer knows that C has committed a murder and for which he has been defended. L induces C to sell off his property worth rupees 1 crore to him for 40 lakhs. So this is a secret, or that the person has committed a crime, and this person gets to know about such secret that he has committed a murder and he has been defended in the court of law for committing the murder. So this person is actually in a power to dominate the person's will, that is C. So he uses that power to sell off his to buy his property worth rupees 1 crore for merely the consideration of 40 lakhs. So this contract would also be voidable contract. So because in this case L was in the power to dominate the will of the person, because he knew a very pertinent secret about him, that he had committed murder, and under the threat that he might disclose that secret that he had committed a murder. So under the threat, if a person enters into a contract for selling his property for lesser consideration, so this contract would also be a voidable contract because there was a undue influence used by a lawyer. Next concepts are misrepresentation and fraud. Misrepresentation, a misstatement of a fact material to the contract. Misrepresentation means that a fact which is material to the contract has been misstated. For example, A wanted to buy an old cricket bat he saw at B's shop and it had a beautiful carvings on the front. B told him that Sunil Gavaskar used to play with his bat. B really believed that Sunil Gavaskar used to play with the fact. So if in this case the mere fact that Sunil Gavaskar used to play with this bat is not true, if it's not true, then it would amount to misrepresentation. However, B is also not aware of the fact that it's true or not. He actually believed that Sunil Gavaskar used to play with this fact. So there was no fraudulent intent in the mind of B. He told whatever he believed so to A. So if on the belief of B and believing that what he's saying is true, A buys that bat, the contract would be under the misrepresentation of the facts material to the contract. So the fact that Sunil Gavaskar used to play with the bat is very pertinent in the contract. So any contract entered into on this basis would be on the basis of misrepresentation and thus voidable. Next concept which is related to misrepresentation is fraud, a deliberate misstatement of the fact material to the contract. In addition to misrepresentation, if there is deliberate misstatement, that is malified intention comes into play, that is malice or bad intention come into play on the part of the person giving that statement, it would amount to fraud. In this case, B had no malified intention, so it was not fraud but misrepresentation. But let's take the same example. A saw an old cricket bat in B's shop with the beautiful carvings on the front. B told him that Sunil Gavaskar used to play with this bat. B never really believed but hoped that A will buy that and purchase the bat. He just told this fact on his own, that he knew that it's not true, but he thought that A will believe him and purchase the bat. Sensing an amazing opportunity to obtain Gavaskar's bat, A purchased it. So on the malified and deliberate misstatement by B, on the basis of that statement regarding the fact which is material to the contract, that is the opportunity to obtain Gavaskar's bat, A purchased the contract. So this contract is on the basis of fraud and hence voidable on the discretion of A. So the difference between both these concepts is the contract was on the basis of misstatement, but it was not malified and deliberate misstatement, but the fraud, in case of fraud, it's a deliberate misstatement. So the intent of the person giving that statement matters to discriminate or differentiate between the concepts of misstatement and fraud. The core principle is contract only avoidable if misrepresentation or fraud caused by consent, right? Next concept is mistake. Mistake is when both the parties to an agreement are under mistake as to the matter of fact essential to the agreement, that both the parties have some kind of mistake on the fact which is essential to the agreement. There are two types of mistakes, that is mistake of fact and mistake of law. We had discussed that mistake of law is not excuse, so only the mistake of fact is allowed. We will understand this with the help of examples later on. Mistake has other fundamental principles also and other types also. Mistake can be as to the identity of the parties involved, right? So mistake of fact is, fact could be identity of the parties. Identity of the parties is also an important and material part of the contract, so the mistake could be in this regard. Let's take an example. A approaches B believing him to be S. A actually believed that it's not B, it's S, and offers to buy his property. B agrees believing A wants to buy his property, that is B's property. A actually intended to buy S's property, not B's property. However, he approached him believing him to be S. On the other hand, B agrees that A wanted to buy his property, that's B's property. So there's a mistake by both the parties with regard to the identity of the parties as to whose property A wants to buy, right? So it's a mistake as to identity of the parties. Next mistake could be mistake as to the substance of the subject matter, as in on the subject matter on which the contract was being entered into. Example, A wanted to sell his plot of land to B. A contract was entered into. However, at the time, the plot of land was acquired by the government, but neither party knew this fact. So there was a mistake by both the parties. They did not know that the property on which they entered a contract into has been acquired by government, so they did not know about this fact. So it's a mistake by both the parties on the substance of the subject matter of the contract. Next mistake could be mistake as to the identity and nature of the subject matter. So it's both the things, identity and nature. Let's take an example. A and B entered into a contract whereby A sold his standing crop to B. It was later discovered that the crop was destroyed by burning at that time the contract was made. So the identity and nature of the subject matter on which the contract was entered into has come into trash, and it's not existing at the time when they enter into a contract. So there's a mistake as to the identity and nature of subject matter in this case. Next example, A wanted to sell his car to B, for which they entered into a contract. It was later discovered that car is actually owned by C. So the identity of the subject matter, that is car, comes into question. They entered into a contract, however the car was owned by C, that is third party. So it's a mistake on this part 2. Next concept which has to be discussed is competency of the parties. The essential agreement of a contract is both the parties to the contract must be competent, subject to the few exceptions listed. A person who is a minor or unsound mind or a person forbidden by law is not competent to enter into a contract. Any other person other than these three kinds of persons would be a competent person to enter into a contract. In case of a minor, there is a rare exception. Contract to supply necessaries of life to minor, enforceable when minor comes to an age. This concept is related to the concept of guardianship. We will take an example of Hindi movies. Many of must have seen in the Hindi movies that there is a child who's a minor, that is below the age of 21 years or 18 years in this case, 18 years. That person is a whose father and mother have died and left a lot of property. So in this case, a guardian was appointed, that person would be taking care of the property on behalf of the minor, the person in the movie, the minor, and on attaining the age of 18 years, the property would be given to the minor. So in this case, if the guardian enters into any kind of contract which is to supply the necessities of life, for example, the person who is appointed a guardian of that minor whose parents have died has entered into a contract with a grocery store to supply all the food essentials and daily requirement things to their house on the behalf of the guardianship, can be enforced when the minor comes to the age of 18 years. That is, the grocery store person can claim the amount of money from the minor after 18 years. So this is an exception to the rule of competency, wherein minor cannot enter into a contract. So these are the contracts which can be enforced after the minors coming into the majority age. Next is lawful object. Law won't support or back up an unlawful object when the basic object of the contract on which it is entered into is unlawful, like killing or murdering or gambling or such contracts which are not legal in the eyes of law. Those contracts would be illegal and not enforceable in the eyes of law. Let's take an example. Sachin lends money to Pretty Jane, who pays Tarun Gamli to kill Madhur, brand master. So there are one contract is here between Sachin and Pretty Jane, that is lending of money, and then another contract is between Pretty Jane and Tarun Gamli to kill Madhur, bandmaster. So in this case, we will discuss how many contracts and agreements are present in this particular transaction and between who all. We discussed that there are two contracts here and here. So we will discuss the validity of these contracts or agreements on the basis of the lawful object. In this case, Sachin's lending money to Pretty Jane would be a valid contract if Sachin did not know the ultimate purpose of use of that money, that is killing of this person. So this contract would be a valid contract. But the contract between Pretty Jane and Tarun Gamli is a void agreement because there is a unlawful object involved in this agreement. That is, it's a void agreement. It would not amount to a valid contract. It's a void-ab-initio, that is illegal or wrong from the very beginning because the object behind this agreement is unlawful, that is killing, which is prohibited by Indian Penal Code. So these are the essentials of a valid contract, and the contract which lacks lawful object would be an void agreement or illegal agreement. So thank you for being with us, and hope the concepts of and ingredients of contract are clear.